everyone, and welcome to today's episode of the UMLaw. I'm your host, ALLYZSA ZAHRIL, and today we are diving into a topic that affects every organizations, every business, and honestly, every individual in the digital age: data protection. So, in today's world, data is often described as the new oil. Every click, transaction, application, and online interaction involves personal data. But with that comes responsibility and increasingly legal accountability. So in this episode, we'll be discussing about what data protection really means, why the role of the data protection officer is becoming crucial, and what organizations in Malaysia need to know about the PDPA amendments, and finally, how professionals can prepare themselves through proper training and certifications. So, and to guide us through all of this, we are truly honored to have with us a very distinguished guest. So, our guest today is Professor BAKAR MUNIR, an internationally recognized expert in cyber law and data protections. So, Professor BAKAR is the chairman and principal consultant of the Data Protection Experts Asia, and he played a pivotal role in the drafting of Malaysia's Personal Data Protection Act 2010, making him one of the key architects of the Malaysia's data protection framework. So he has advised governments, including Malaysia, Indonesia, and the UAE, has taught at leading universities around the world, and has spoken at international platforms such as Oxford, Cambridge, and MIT. Professor, thank you so much for joining us today. It is truly an honor to have you with us.
Thank you so much.
So we're really looking forward to learning from your insights today. All right, so let us start off this conversations. Professor, could you explain in simpler terms what we mean by data, personal data, and sensitive personal data, and what data protection is as a whole?
Thank you so much, ALLYZSA, for having me here. Thank you so much, UMLaw, for inviting me for this session. And to answer your questions, talking about data or personal data in specific, if you look at the definition around the world, it's basically data relates to an individual. And some countries like New Zealand, for example, specifically says it has to be a living individual. So any informations that can identify or that identifies individual or that can make someone identifiable are personal data. So this may include your IC numbers, your phone numbers, and to some extent your email addresses, and other informations that make someone identifiable. So that's personal data. And sensitive data normally involve a stringent requirement and strict requirement. It involves, for example, financial data, your health data, and your retina data, for example, and your other. And in Malaysia, political affiliation is sensitive data. Religious background is sensitive data. So personal data and personal data protections basically protects those data of individual human being. Yeah.
So that's very interesting, and it's a new knowledge for me to know that there's a difference between personal data and sensitive personal data. So thank you so much, Doctor, for answering that question. Professor, for answering that questions. So let us move on more deeply, a bit personal. So Professor, you've been involved in data protection long before it became a global trend. So
Yeah.
could you share a bit about your personal journey into this field, and what made you realize that data protection would become such a critical area?
Yeah. Thank you so much again for the questions. If I remember correctly, my first book on cyber law was published back in 1999. First book in Asia about cyber law. And I remember when I was talking about cyber law, no one will pay attention to that. And I remember when I was invited to Dubai to give a lecture at the Dubai Chamber of Commerce. So I was talking about cyber law implication and what is going to happen. And I see the reaction was I mean, they were not interested. But now this is the in thing. And one important element of this cyber law is, of course, data protection. So data protection is very, very important. And as it is now, I think around 160 countries around the world which have enacted comprehensive data protection law. So it shows the importance of the subject matter. And in this part of the world, of course, we have recently Brunei Darussalam. Brunei Darussalam has enacted a law, and before that, Vietnam. Yeah, and I was recently in Cambodia, Phnom Penh. So Cambodia is developing a law on data protection. So I was invited to give my opinions and my views on the draft law. So, yeah, interesting, basically, area and very fascinating area of law and practice. Yeah.
That's very insightful, Doctor. Especially hearing how, like, you recognize the direction in technology, how you were basically pioneering like the data protection landscape in internationally. Okay, so let us move on to the next question, Professor. So you were directly involved with the drafting of the Malaysia's Personal Data Protection Act back in 2010, right?
Right.
Which was one of the earliest data protection laws in the region. So looking back now, are there any experiences that from that drafting process that stand out to you? Perhaps maybe like challenges or decisions that significant to you.
Yeah, thank you so much. Very interesting questions because, this is something new in this part of the world. And I was working with the staff of the AG Chamber's office, So I still remember I was traveling to Washington for a conference, and I received a call from the ministry. At that time, it was the Ministry of Communication and Water. Communication, Energy, and Water. So I received a call asking about, how to formulate certain provision in the draft law. And to me, that is a very interesting, experience because, as I said, it's something new, and there are a couple of things that I cannot sort of convince the government. I think that's I mean, to me, it's very sad thing, if I may say so, because I wanted to have something in line with the international best practice. For example, the coverage or the scope of the law, it should apply to government or public sector, but the government of the day at that time refused to have that. Okay, and the other point is about limiting the act or the proposed law then to commercial transaction. So I did mention to the ministry it was not a good practice. It should be, applied to commercial as well as non-commercial transaction. So, so that experience of trying to convince the government to do certain things, unlike, I have been advising Dubai government, as you may know. I think it's a bit easier as compared to advise your own government. Okay.
I think it's because it's probably like very new and
Yeah,
like unfamiliar.
exactly. Yeah.
Thank you so much for that. We really appreciate how much thought that went into the drafting of the uh, Personal Data Protection Act. Yeah, thank you so much, Doctor. Thank you so much, Professor. Okay, so let us move on to the strength and weaknesses of the
Mhm.
PDPA
Yeah.
agreement.
Yeah.
So it has now been more than a decade since the PDPA came into force. So from your perspective, what do you see as the key strengths of the PDPA, and
Okay.
where do you think improvements were
Yeah.
necessary?
Okay. Yes, we did the amendment last year, and the rationale is, of course, trying to align our PDPA with the international best practice, especially EU GDPR, European Union General Data Protection Regulations.
Mm-hmm.
So, in the new amendment, we have elements like data breach notification. We have we have amended, or the government has amended some key provisions in terms of definitions. Then they increase the penalty. Then a new right called the right to data portability has been introduced. So those are basically common elements in the international data protection regime. So, yeah, but there are other things that should be included in the amendment. Perhaps the government should consider having a new amendment and to include new things like provisions to address AI or AI risks,
Yeah.
artificial intelligence risks. For example, if you look at data protection law around the world, there must be a provision on ADM, automated decision making. So we don't have that in Malaysia. So perhaps this is one of the things that the government should consider in the next exercise or next amendment. Yeah, and yep.
All right. That's a great point. And actually, this discussions like leads us perfectly into our next segment, which is the role of the data protection officer,
Yeah,
which has become increasingly important following the recent amendments.
yeah.
Okay, so I want to ask Professor why that data protection officer role became mandatory,
Yeah.
because like recently Malaysia introduced like a clear requirements for appointing a data protection officer. So before this amendment, what gaps or issues were actually regulators seeing, and was it mainly due to data breaches, like maybe digital growth, or just lack of accountability?
Yeah, yeah. I think you mentioned it quite rightly. Yeah, and again, Malaysia is quite late in this aspect. DPO requirement is already in many parts of the world. Um, I think altogether now there are 62 or 65 countries requiring DPO or mandating DPO to be appointed in certain circumstances. I have to say that in certain circumstances, yeah. Yes, one is accountability. Yeah, we have to have someone who can basically responsible to ensure compliance. So that's the whole idea about DPO. And before this, perhaps many companies or many organizations in Malaysia, they will basically designate customer service to handle data protection matters. And as we know, customer service is not a specialized individual or specialized staff. So having DPO, I think, is a good move basically by the government, and hopefully by having DPO in our organizations that can help companies and organizations to comply to the law. So the whole idea about DPO is ensuring compliance.
Ensuring
Yeah.
compliance. All right. So, relating that question, how does Malaysia's DPO framework compare with the international standards
Yeah.
like the GDPR? And are we moving toward the global alignment,
Yeah.
or is Malaysia developing its own unique model?
Okay. Interesting question. Okay, we look at the situation around the world again. Yeah. Um, there are three sort of categories of organizations which are required to have DPO. One is the first one, under EU GDPR, under Indonesian law, under Vietnamese law, and other countries' legislation, public sector or public sector agency, or in a broader terms, EU GDPR and other legislation mentions about public sector on organization processing for the purpose of providing public services. Okay, that is one. Public sector agencies. Yeah. Then secondly, companies dealing with sensitive data, or companies, organization processing sensitive data. They have to have DPO. Yeah. And thirdly, of course, companies processing personal data for the purpose of monitoring or profiling. So those are the general categories of companies, organizations that must have or must designate DPO. Yeah. So if you look at Malaysia, we have the guideline issued by the commissioner. It says, under and paragraph 4.2, personal data exceeding 20,000 data subjects. Companies processing personal data exceeding 20,000 data subjects are required to have DPO. So I would say this is something similar to what the position in China. Yeah. And the other category is, of course, companies processing sensitive data exceeding 10,000 data subjects. Yeah, that is second category. And the third category is, of course, companies processing personal data, and it involves regular and systematic monitoring of personal data. This is normal. The third category is basically international requirement. Yeah. So the first two basically differentiate Malaysia with the rest of the world.
It's interesting to hear like the balance and also the difference
Yeah.
between like globally and internationally the practices and also our from like local context.
It is quite understandable, Alicia, because PDPA does not apply to public sector agencies. So therefore, the requirement of DPO is irrelevant in that context. Yeah, meaning that you cannot impose DPO for public sector agencies because the law itself doesn't apply to public sector agencies.
Understand.
Yeah.
All right. So now let us move on to why 1 June 2025 matters. So 1 June 2025 is often mentioned as a very important date. So why is this deadline so significant, and what are the risks if organizations are not prepared by then?
Basically, 1st June 2025 is the, if I may use the term, deadline for companies to have their DPOs or to appoint DPOs. Yeah, I meant basically the enforcement date of the requirement for DPO. And I'm not sure what is the position now. Perhaps companies are struggling to appoint or to make someone as their DPOs, and I think it's very important to have qualified and capable DPO. So naming someone is not, to me, is not compliance. Yeah. Okay. So 1st June is basically the deadline to comply with the DPO requirement.
All right, so that's definitely something that organizations should take seriously,
Yeah, yeah,
and especially with like enforcements
right.
of it. Um, Another question, Professor. Could you help us understand what exactly, like who exactly must appoint a DPO? Like for example, for the 20,000 and 10,000 data
Mm,
subject
mm.
thresholds, right? So what do these actually mean in like practical
So
terms?
basically, this requirement 20,000 and 10,000, it says personal data of data subject. And we have to remember data subjects here may include your staff. So data subject here does not necessarily mean just the customers. Okay, if you have 20,000 customers, of course you have to have DPO as required by the guideline. Yeah, but this 20,000 can be your staff members, meaning that if you are a factory, for example, yeah, you don't basically collect much data, if I may say so, but the fact that you are having 20,000 employees or factory workers, so therefore DPO is mandatory for companies as well. I mean, for manufacturing companies, even though they may not process the so-called complex data, but the fact that they are having 20,000 employees require them to have DPO. So 20,000 and 10,000 here, 20,000 and 10,000 sensitive data here may include, can include the staff members or employees' data. Yeah.
So that clarification is very helpful because especially for maybe like businesses and organizations who may think that this doesn't
Yeah.
apply to them.
Yeah. Manufacturing companies, as I said, or manufacturing organization may argue that no, we don't collect too much data from our customers because we manufacture products, automotive or whatever. But the fact that, as I said just now, you are having 20,000 or more employees or factory workers, basically you fall under that category. Okay?
Yeah, okay. So on that, when it comes to SMEs, monitoring and also accountability. So do SMEs and startups like need to be worried about this? Like when the guidelines talk about regular and systematic monitoring. So what does that actually mean in daily operations?
Uh, let me refer to they have given the examples here. Um, I think what is mentioned there, the word regular and systematic. The word regular means ongoing or occurring at particular intervals for a particular period. Yeah, recurring or repeated at fixed times, constantly or periodically taking place. So that's the word regular, based on the guideline and the guidelines issued by many regulators around the world. And the term systematic refers to one of the following basically activities occurring according to a system, pre-arranged, organized, or methodical, taking place as part of a general plan for data collection, carried out as part of a strategy. So if it falls under those category, one of those category, that means you are doing systematic and regular monitoring of data subject or individual. To make it simple, if you are, for example, operating a telecommunication network or providing telecommunication services, you are doing email retargeting, you are doing behavioral analyzing, you are trying to analyze the behavior of your customers and and what other forms of profiling they form. It falls under that category 3, which require DPO to be appointed. Okay.
So, last question for this segment, Professor. So, when appointing a DPO, right, what skills should organizations look for? And is it better for them to like appoint someone internally or outsource the role?
Um, Appointing someone from within the organization has some advantages. And the second option, basically outsourcing it to a third party, has some advantages as well. If you are appointing someone, if you are outsourcing it to a third party, normally the DPO will be more objective in making the decision, in trying to guide companies towards compliance. Yeah. If you are appointing someone from within the organizations, what is important is that this is mentioned indirectly or directly, if I'm not mistaken, in this guideline, and of course it's mentioned in other regulations. The DPO must be given some kind of autonomy to perform their duties. So they must be independent. The DPOs must be independent because they are supposed to check, they are supposed to assess, and they are supposed to advise you whether you are okay in terms of data protection and processing data and PDPA. So it's very much up to the company or business decision. Yeah. Taking into account the financial resources, perhaps, taking into account your human resources, perhaps. Yeah. So it's up to the organization. Okay.
Thank you so much, Professor. So that brings us nicely to the next part of our discussion for the next segment about training, governance, and also preparing future data protection officers. Thank you, Professor.